Our next presenters are Ravenna Hederi and Andrea Ledrew, who will be presenting on a range of different cases. These ones don't fit into any certain category and are just sort of a mix of cases that we thought might be of interest to you. You'll see Ravenna is dressed a bit differently this morning. She's not going out for Halloween early. She is at a trial, and it's being held down until she's completed her presentation this morning, so that explains her appearance. So thank you very much, Ravenna, and go ahead.
Good morning, everyone. Thank you for being here today. I wish I would have the opportunity to meet you in person. However, for now, we have to do this virtually. We will talk about today about some cases that we have covered under insurance potpourri. Potpourri, an unusual or interesting mixture of things. Only us in the business may find these things as entertaining and as interesting as the potpourri is. First off, I will cover policy exclusions and clauses and court discretion and costs, and my friend and esteemed colleague Andrea is going to cover the rest. The first case I'm going to talk about is Tetrin at the suit of AXA Insurance Canada. It's a case that went to the Court of Appeal. The plaintiff, Susan Tetrin, brought a summary judgment motion, and this case involves a construction exclusion clause. Susan, the plaintiff, had purchased home insurance comprehensive policy as well as a business interruption endorsement in view of the fact that she was carrying out her law business at the time at home. Her house was undergoing some renovations when, surprise, surprise, she had her first plumbing malfunction and the loss of December 10, 2010. AXA did cover this loss. However, while renovation was still ongoing, the second loss, the boiler system malfunction of March 6, 2012, occurred. AXA denied coverage for the second loss. The basis for denying coverage for the second loss was basically the clause up on the screen, and the key part being the underlined one: we do not insure loss or damage occurring while the building is under construction. Now, the part of this clause under construction is the interpretation that the judge involves in what does it cover and what does it not. In order to do so, the motion judge refreshed the principles of policy interpretation that he relied on, such, and I'm sure all of you know, however, for ease of reference, here they are again. Coverage provisions should be interpreted broadly and exclusions narrowly. The policy should be read as a whole. If the policy is ambiguous, courts should rely on general rules of contract construction, giving preference to interpretations consistent with the reasonable expectations of the parties. In this case, the motion judge relied on the Black's Law Dictionary definition to interpret under construction in the exclusion clause, primarily the part that relates to the creation of something new as distinguished from the repair or improvement of something already existing. In reference to this, the judge also relied on the BC Court of Appeal, which had initially referred to this definition in order to interpret what under construction would mean. Ultimately, the motion judge concluded that renovations did not classify as under construction. And in so doing, the judge was involved in a fact-finding mission. The key takeaways in this case are renovations does not equal under construction. As indicated earlier, the motion judge relied on the definition of Black's Law Dictionary and Court of Appeal of BC in order to interpret that renovation did not equal under construction. The second takeaway is, unless defined in the policy, under construction is subject to the interpretation of the court. And in so doing, the court, again, has discretion to rely on extra-jurisdictional publications and authoritative case law. Court's discretion to engage in fact-finding is undeniable, and hence the Court of Appeal upheld the decision of the motion judge. The next case I'm going to talk about involves another exclusion clause, and this one involves marijuana exclusion clause. Our own Frank Chatty and Mike Connolly argued this case successfully and virtually indeed. This case involves a summary judgment motion brought by both parties, the insured as well as the insurer. The insured in this case had rented the residential property, and when the renter was supposed to leave the property for failing to pay rent, the explosion happened while the renter was in the process of raising extraction. Now, I'm not an expert, I don't really know what it is, but I know it involves quite some propane and other substances that ignited a fire. The renter pled guilty to drug-related charges. Aviva denied the loss claim on the basis of the following exclusion clause. Basically, whether or not the insured is aware of such activity or use of the property, coverage is denied. The insured tried to rely on innocent insured legislation. The loss occurred in March 2016. The innocent insured legislation entered into force and effect in 2018. What the insured was attempting to do was to rely on this legislation on the basis that it applied retrospectively to the loss at hand. However, Justice Pinto disagreed. Marijuana exclusion applies to exclude coverage irrespective of Section 129(1) involving the innocent insured legislation. The exclusion is based on certain uses from coverage regardless of the insured's conduct. Legislative amendment, on the other side, may differentiate between innocent conduct of insured or culpable conduct of the person responsible for the loss. In order to conclude that the innocent insured legislation did not apply in this case, reliance was placed on the principles laid out in R versus Dinley of the Supreme Court of Canada, which involves rules of interpretation whether legislation should apply retrospectively or prospectively. In conclusion, the Innocent Insured Amendment to the Insurance Act does not apply retrospectively on the marijuana exclusion contained in the policy. Some interesting, at least in my view, reasons articulated by the judge in finding in favor of Aviva are the following. The parties had entered into a contract of insurance. Aviva had the substantive and vested right to deny coverage pursuant to the marijuana exclusion clause of that contract. Retrospective application of the amendment would mean looking back into the contract and prejudicially affecting Aviva's ability to exclude a loss from coverage. Some key takeaways. New legislation should not apply retrospectively when it is more beneficial to one party and may prejudicially affect the substantive and vested rights of the other parties. Innocent insured legislation does not trump the marijuana exclusion. And the last one I would add, perhaps, is anytime you want to determine whether you can or cannot apply legislation retrospectively or prospectively, take a look at R versus Dinley, which is fully quoted even in the relevant section in paragraph 40 of Lynn. The last case that I'm going to talk about, and I'm sure that you are all very familiar with, is a case typical, in my view, when you can do everything right, and yet the court ain't going to give you any money for the costs involved in litigation. This is the case that an elderly woman slipped and fell outside her retirement home. Damages were agreed upon, and trial proceeded on liability. The verdict was favorable for the retirement home. Nevertheless, the trial judge denied costs to the successful party. As we all know, typically the successful party is entitled to costs. That's the general rule. Discretion of the court is ultimately what swings things in favor of one party or the other. In exercising such discretion, the court is supposed to take into account the factors laid out in the rules of civil procedure, such as nature of issues, outcome of issues, behavior of the parties. The court is not supposed to rely on parties' resources or identity as a relevant factor in such exercise. Another factor that the court is going to look into is whether access to justice is denied to a party. In this particular case, the Court of Appeal found that access to justice was not denied to the plaintiff. She had an experienced counsel at trial. She called experts at trial. She had purchased adverse cost insurance, and that insurance would cover the cost in litigation. The Court of Appeal concluded that the judge's decision reflected errors in principle, some of which are laid out below. Existence of an insurer behind a party, availability of insurance in favor of a successful party at trial, difference in financial position between successful and opposing party when any financial advantage does not constitute an abusive tactic or misconduct. And another interesting reference was the David and Goliath that the trial judge referred to, which likely affected the way in which he decided in favor of not granting any cost awards to the retirement home. The trial judge's decision in this case is arguably contrary to Bell Canada versus Olympia. And the reason is that ultimately the verdict of the jury confirmed that the retirement home was correct in not settling liability. Nonetheless, the Ontario Court of Appeal concluded that the judge did not err by refusing to award costs because of the imported societal and legal context of elder care and negligence law. Now, after identifying all the errors in principle committed by the trial judge, the only factor that did swing things in favor of not disturbing the trial judge's decision was novel issue, elder care. Whether that is a novel issue or not, that is subject to debate. Some key takeaways, again, that I'm sure you're familiar with, is that costs are discretionary, a reminder to all of us when we proceed with a motion, with a trial, etc. The appellate courts show deference to the trial judge. They may critique the decision in principle. However, novelty, again, may tip scales in determining a no-cost award. Thank you for your time, and have a great rest of the day.
Okay, thank you very much, Ravenna. There was one question following up, Ravenna, but I'll field it because it's on my case, the Aviva and Lynn case.
Thank you.
So, first of all, that case is under appeal, and the appeal is being heard on November 1st. So you should be hearing, if the court agrees with the motions judge, probably sometime next spring. But the question is this: was there a mortgage in that case? If so, was the mortgagee protected, and did they seek recovery? So I honestly can't remember now if there was a mortgage in that case. I think that it's clear that the marijuana excludes coverage for that type of damage, damage caused by a cooking operation of cannabis. So I don't think the mortgagee would recover either. The policy just does not cover that type of loss. And it would affect both the mortgagee and the landlord who took the commercial risk that there might be an uninsured risk with respect to any given tenant. So I hope that answers the question. Some people said good luck at the trial, Ravenna. I'll pass that on. And now we'll move to Andrea Ledrew. Andrea is going to be covering a few more cases that you might find of interest. Thank you.
Hello and good morning. Over the years, when I've received a slip and fall claim that occurred while a person was getting into or out of a vehicle, I've always been pleased because it's meant that the person would be simultaneously making a claim under the SABs, and my client in the tort action would be entitled to deduct those collateral benefits, whether they be income replacement benefits, med rehab, etc. With this case, it appears that the tides are turning. So the facts of this case have a plaintiff who's at her parents' house and orders a lift car to come and pick her up for a medical appointment. It was a snowy winter day, and her parents' driveway was covered with snow and ice. The lift car arrives and parks less than halfway up the driveway, and the plaintiff makes her way down to the vehicle and has to put her hand on the vehicle in order to steady herself. And before she makes it into the lift car, she slips and falls and breaks her leg in 2 places. The plaintiff made a claim for benefits under the SAB, saying that the fall was an accident which occurred during the use and operation of a vehicle. Aviva denied the claim on the basis that the incident was not an accident under Section 3.1 of the schedule. So this went to the Licensing Appeal Tribunal, or the LAT, which found that the plaintiff's injuries were the result of an accident within Section 3.1 of the schedule, or in other words, the LAT found that the accident occurred in a situation where the use or operation of a vehicle directly caused an impairment. Aviva requested a reconsideration of this decision, and the LAT confirmed its previous position. Aviva then appealed to the Ontario Divisional Court, and Justice Bell allowed the appeal. So the central issue on this appeal was Aviva's submission that the vice chair had misapprehended the causation test. The vice chair had concluded there were 2 direct causes of the plaintiff's injury, the icy snow-covered driveway, and as a result of the use and operation of the car that stopped less than halfway up the driveway. This was an error of law. Legal entitlement to accident benefits requires not just that the use and operation of a car be the cause of the injury, but that they be a direct cause. So this has been referred to as the Chisholm causation test from the Court of Appeals decision in Chisholm and Liberty Mutual Group. In this case, the use or operation of the lift car could not be said to be the direct cause of the plaintiff's injuries. More was required than establishing that the car brought the plaintiff to the location where the incident occurred, and more was required than the car being the reason why the plaintiff was at that location. The dominant factor or dominant feature in the plaintiff's injuries was the icy, snow-covered driveway, and that the use of an operation of a vehicle was at best ancillary. So as I mentioned earlier, under the older legislation, accident was defined more broadly, and it's likely that the plaintiff's claim would have succeeded. Tides are changing now, so that plaintiffs will need to demonstrate that the dominant feature of their injuries are the very use and operation of the motor vehicle. There have now been a number of cases that have decided similarly, where the use and operation of the vehicle has been found to be at best ancillary and not the dominant feature of the plaintiff's injury. One of these cases is Chisholm and Liberty Mutual Group, which is a 2002 Court of Appeal decision. In this decision, the plaintiff was rendered a paraplegic after someone fired gunshots into his vehicle. And Greenhalgh and ING Halifax, which was a 2004 Court of Appeal decision. The plaintiff's car became stuck on a country road on a snowy evening. She got out of the vehicle and tried to retrace her path, became disoriented, and suffered severe frostbite. In Mahadin and the Cooperators General Insurance Company, which is a 2001 FISCO decision, the plaintiff was emptying his car of groceries, and as he turned away from the trunk, his left foot became stuck in a groove in the pavement, and he fell on his left side. In those cases, as in Porter, it was held that the incidents were not the result of an accident within the meaning of Section 3.1 of the schedule, as the use and operation of the vehicle was not the dominant feature in the plaintiff's injuries. So I'd now like to shift gears and speak to you about vicarious liability. You may have the general impression that an employee is not acting in the course of their employment during coffee breaks or lunchtime. This case held differently. So this is a cluster of summary judgment motions and 2 companion actions. Slavco Concrete Finishing was a company based out of Ottawa, which sent its employee, Guy Pellerin, to conduct a pour and finish of new concrete at a military base in Petawawa, which is about a 2-hour drive west of Ottawa. So Slavco, pursuant to the collective agreement, was obligated to arrange for travel for its employees, and it did so for 5 other employees attending the site. But Mr. Pellerin's supervisor called him to say that he would need to be there earlier and would have to take his own vehicle. So before leaving Ottawa, Mr. Pellerin fueled up, grabbed a coffee, ran an errand, and then drove on Highway 17 towards Petawawa. And during that drive, he stopped to grab a coffee in the town of Renfrew. In the course of this stop, he drove into the plaintiff's vehicle, injuring the plaintiff and her passenger. And the various plaintiffs sought damages in the amount of $3.6 million. This exceeded Mr. Pellerin's $2 million insurance limits. So the question on the motion was whether Mr. Pellerin was acting within the scope or course of his employment such that his employer, Slavco, was vicariously liable for the negligent operation of his vehicle. The court held that Slavco was vicariously liable. Companies will be found to be vicariously liable for torts falling within the scope or course of employment if the acts were authorized by the employer or if they're unauthorized acts by the employee so connected to the authorized acts that they may be regarded as modes, albeit improper modes, of doing an authorized act. Justice Kane found that Mr. Pellerin was acting in the course of his employment while driving to Petawawa based on a number of factors. So first, Slavco's business operated out of the Ottawa area and often required employees to travel long distances, such as to Petawawa, as part of its business. Slavco's employees always went directly from their residence to the work site without stopping at Slavco's head office first, and Slavco directed Mr. Pellerin to drive to Petawawa and back, which was some 4 hours of driving and 340 kilometers. Mr. Pellerin was carrying the tools of his trade in his vehicle that he needed for the concrete finishing work, and pursuant to the collective agreement, he was entitled to payment for mileage and travel time. Notably, Slavco did not present any evidence that it arranged for alternate travel for Mr. Pellerin. The court found that Mr. Pellerin's attempted turn and intention to stop, stretch, grab a coffee was a mere deviation or a brief detour which was incidental to his drive to Petawawa, and Slavco did not prohibit employees from making this kind of stop. So it's worth mentioning that the court spent some time discussing a policy of providing a just, fair, and practical remedy to victims of wrong by employees. They noted that the employer-employee relationship is most common to attract vicarious liability in order to serve policy goals of fair and effective compensation to the people harmed by the employee. If an employer creates a risk in order to advance its own economic interest, that when the risk materializes and causes injury to a member of the public, the employer should be liable for the losses incurred in the course of that enterprise. They also discussed the goal of promoting deterrence so that employers take steps to reduce harm or accidents by measures such as efficient organization and supervision. In the case at hand, Slavco required its employees to frequently travel considerable distances in their vehicles. This enhanced Slavco's business opportunities, and the business of Slavco created the associated risk which occurred, and therefore the court found it legally responsible for the loss associated with that risk. So I'd now like to discuss case that involves allegations of bad faith against insurers, which is something that we all must be attuned to. So in this case, the plaintiff was diagnosed with major depressive disorder. She took a medical leave from work, and during that time received short-term disability and then long-term disability benefits from her disability insurer, Sun Life. She attempted a gradual return to work and had made it to 4 days a week when her treating psychiatrist advised that there had been a worsening in her depressive disorder and that she should be maintained at 3 days a week. In spite of this, Sun Life terminated her benefits at the point that she was supposed to return to work full-time. So the central question in this action was whether the plaintiff was entitled to long-term disability benefits beyond the date that Sun Life terminated them. The plaintiff's policy with Sun Life included 2 periods of coverage, the first being own occupation and the second any occupation. The own occupation period refers to the elimination period and then the first 24 months that she was not able to perform the duties required in her own position. And then the any occupation period was at the change of definition where she would be provided with benefits if she was totally disabled from any occupation for which she might become reasonably qualified by means of education, training, or experience. So Justice O'Brien held that the plaintiff met the requirements for payment in the own occupation period and not the any occupation period. Sun Life in this case relied on the evidence of a health management consultant who took carriage of the plaintiff's file and said that she was not returning to work because she wanted a better work-life balance. Justice O'Brien preferred the evidence of the treating psychiatrist and stated that an insured person who is in recovery and has been medically advised to return to work at a reduced level should not be considered to be making a lifestyle choice. It's notable in this case that the psychologist retained by Sun Life also agreed with the plaintiff's treating psychiatrist, and the plaintiff's supervisor also attested to her inability to perform the essential duties of her work on the days she did attend. Taken together, the evidence supported a finding that the plaintiff was not capable of performing the essential duties in her own occupation or performing substantially all of the duties of her position. However, she was not entitled to benefits during the any occupation period because the job she had at the time of trial, working 3 days a week, was reasonably comparable to her old occupation in status and in reward. In addition to being suitable given her education, training, and experience, she held the same title as her old role and performed some of the same tasks and earned around 73% of her previous income. So finally, Justice O'Brien held that Sun Life breached its duty of good faith to the plaintiff for the following reasons. First, Sun Life adopted the position that the plaintiff sought a work-life balance and maintained it during the trial despite overwhelming evidence of her disability. Sun Life discontinued her benefits without sufficient medical evidence as to her state and held on to that position even though it never provided an opinion from a doctor that contradicted her treating psychiatrist's opinion. And it did so while the plaintiff was participating in a gradual return to work program. And finally, Sun Life failed to show an open mind when reviewing additional medical documentation and oversimplified the plaintiff's condition. So the key takeaway here is to be careful to periodically evaluate entitlement positions as information is learned throughout the duration of an action and into trial.